The Federal Court of Appeal has handed down its ruling on the bid by Rogers Communication to take over Shaw. After a one-day session, the court rejected an appeal by the Competition Bureau, which was seeking to block the deal. The Competition Bureau argued the transaction would lessen competition in Canada's telecom industry, which has some of the highest mobile prices in the world. It went to the Court of Appeal after it failed to convince the Competition Tribunal that handles merger disputes to stop the deal. The tribunal approved the deal on December 30th. Before today's ruling, the Federal Court of Appeal said it would only interfere if the tribunal committed, quote, palpable and overriding errors in its decision. Rogers hopes the merger will go through by the end of the month, which is next Wednesday, but it still requires approval from Industry Minister François-Philippe Champagne. In a tweet posted last hour, he says he is reviewing the Court of Appeal's decision closely. He adds, quote, promoting competition and affordability in the telecom sector has been and remains my top priority. For more on this, let's bring in Michael Osborne. He's a competition lawyer with Cozen O'Connor Law Firm, and he's been tuning into the hearings all day, and we've reached him now in Oakville, Ontario. Michael, welcome to The Rundown. Thank you for joining us.
Thank you, Hillary.
Let's start with your reaction to the court's decision.
So it's not surprising. The tribunal found that the merger, as modified by the divestiture to Videotron, would actually be good for competition. It would provide for more competition than would be the case had the merger never happened. Now, in the face of that finding, which got a lot of deference because factual findings from a trial court like the Competition Tribunal are generally not interfered with by an appeal court, all of the very technical arguments that the commissioner advanced on appeal, they just didn't matter, because the answer to most of them was, well, the tribunal found that the transaction would actually increase competition. And so in the face of that, and the court said that's enough to dismiss the appeal, the fact that competition would increase.
So help us understand a little bit more here why, in your view, that the Bureau ultimately failed to try and persuade the court that there had been some sort of error here.
Well, I think first and foremost, because there was no legal error. The commissioner had advanced a very technical case before the tribunal as well. He said, you know what, we shouldn't look at the actual merger that the parties are going to do, shouldn't look at Rogers buying Shaw after Shaw divests Freedom to Videotron. Instead, we should look at something that will never happen. We should look at it as though Rogers were going to buy all of Shaw. The tribunal refused to ignore reality, as it put it, and the Federal Court of Appeal refused to embark on a flight into fiction and fantasy. So the appeal essentially was founded on a bunch of technical arguments that failed in the tribunal and that failed in the Court of Appeal precisely because they were wrong. They didn't make sense. And they were also just a bunch of technicalities that were swept away and overwhelmed by the tribunal's finding on the facts that this merger would increase competition.
So what do you think happens next here then? Do you think the commissioner will appeal to the Supreme Court?
I don't think he will. He might. He would need to seek leave to appeal. That is, the Supreme Court would first have to agree to hear the appeal. I don't think that this case is one that the Supreme Court is going to want to take on. Yes, it's an interesting question, but the Federal Court of Appeal and the tribunal have provided a very good answer to it. And I think there'd be no reason to look at that. So I think what's next is we have to, all eyes turn now to Minister Champagne. And my own view is that at this point, it's not his job to second guess what the tribunal said about the competitive impact of this transaction. The tribunal has held, after listening to witnesses for 17 days, has held that the transaction would increase competition. I don't think he has any business doing anything other than saying, right, the tribunal has made a finding, it's been upheld on appeal. Now I have to transfer the spectrum to Videotron, with the commitments, of course, that he insisted on and that Videotron very happily gave him. So I think we will see that the spectrum will be transferred very, very soon.
And Michael, with the 30 seconds I have left here, you've been following this closely. You've been reading into all of this. What do you think? Do you think that this is going to lead, if this merger goes through, of course, to higher phone bills for Canadians?
No, I don't. The Competition Tribunal held that Freedom would be more competitive if the merger went through. Even the commissioner's own economic expert said that Freedom's prices would go down. So the answer is obvious. Even if the other phone companies don't change their prices, if people want lower telephone bills, there's now going to be an option, Freedom, Videotron, whatever they want to call it, that will offer lower bills for people that want to pay less.
Okay, we'll have to see if that does happen, but I do think that's probably something that a lot of Canadians would like to hear. Michael, thank you so much for your time this afternoon. We do appreciate it.
Thank you.
Michael Osborne is the chair of the Canadian Competition Practice at Cozen O'Connor Law Firm.